Hi, I'm Matt, and I'm here on my patio with my beverage, and I'm going to talk to you about the latest Supreme Court religious rights case, which is Fulton versus City of Pennsylvania, decided just yesterday unanimously, to everybody's surprise, I think, who was paying attention. But not very surprising if you actually read the opinions, which are actually extremely disappointing. So, to set the stage, this is a long run. This is another entry in the long running dispute between religious rights, conservative Christian religious rights, I should say, and LGBT discrimination. I'm going to be looking back and forth. And if that annoys you, fine. This is a one take, no edit video. This case involved Catholic Social Services, which assists the city of Philadelphia in placing children in foster homes. And the issue was that CSS, due to its increasingly esoteric views about marriage, was refusing to certify any same-sex married couples for foster home services. And the city of Philadelphia instituted a non-discrimination policy where they would no longer allow any agencies to participate in their foster program unless they were willing to accept same-sex married couples, as foster parents. And the CSS sued Philadelphia, claiming infringement of their free exercise rights under the Constitution. So, going back, what this case touches on and the framework and the kind of sandbox that we're playing in is the framework established by Employment Division versus Smith, which you're familiar with. If you watch my videos from last year, which you probably have and forgotten about. I'm not going to go through the whole story, but the basic idea in Employment Division versus Smith is that exemptions to generally applicable laws on the basis that the law interferes with your religion are generally not available. And the Smith case involved a Native American gentleman who was denied unemployment benefits because he was violating federal drug laws, maybe state drug laws, somebody's drug laws, for using peyote. And he said, I have this religious practice that requires the use of peyote. Therefore, it's unfair of you to apply this law against me. And the Supreme Court said, no. Generally applicable law, you don't get to get out of it because of your religion. Very unpopular decision at the time. Just sort of Sturm and Drang about it faded away, but a lot of people are still unhappy with that decision, including people like me. So the Fulton case was seen as an opportunity to kind of revisit Smith at long last, almost 30 years later, and perhaps overturn it, perhaps alter it, perhaps reaffirm it. And I'll get to what they actually did with it, which was nothing, in a few minutes. The other piece of this, sort of closer to the ground of what normal people care about, is this idea of the conflict between, as I said, certain religious rights and LGBT non-discrimination laws, most recently illustrated in a similarly disappointing way in the 2018 Masterpiece Cake Shop case, which involved, as I think many of you know, I'll just be brief, Jack Phillips, the baker here in Metro Denver. Here in Metro Denver, where there's June gloom and 100-degree weather on the same day. Why do I live here? I'll tell you why, because I have a big patio and a big house. That's why. Mr. Phillips refused to bake a cake for a gay wedding. He was charged and prosecuted under Colorado civil rights law. He was fined or punished somehow, and that went to the Supreme Court. And everybody was hoping the Supreme Court would answer the question of, are religious objections grounds for exemption to LGBT non-discrimination laws? A lot of people think that the Supreme Court answered that question in the affirmative. They didn't. What they actually found, and you know this if you know me, because I correct people on this all the time. What they actually found was that in the course of administering and prosecuting the Masterpiece Cake Shop case, Colorado state authorities were disrespectful and dismissive of Mr. Phillips's religious beliefs. They were mean to him on the basis of his religion, so found the court. If you read the transcripts, I think there's reasonable grounds to disagree with that. Nonetheless, that's what they found. And they said that that alone was sufficient to trigger a constitutional violation, regardless of whether the underlying rule, punishment was righteous for the rule violation. So, Masterpiece Cake Shop. My dog is here flapping around. Yes, I know. It's very exciting. Masterpiece Cake Shop left that question unanswered, so when Fulton came along, everybody was thinking, well, here it is. This is the Masterpiece Cake Shop again. They can't dodge it this time. I'm sure Philadelphia was very careful in their dealings with CSS. We're finally going to know whether a religious objection to an LGBT non-discrimination law will fly. Not only that, we may get an answer to the broader question of whether the Supreme Court still poo-poos individual religious exemptions to generally applicable laws. Well, the Supreme Court dodged the question again in a very Chief Justice Roberts-y way. It turns out there was a little noticed exception in the Smith decision itself to the Smith principle, and that is this. You cannot go out and demand an exemption to a law of general applicability on the basis of religious belief. If I get a ticket for jaywalking, I can't say to the police officer, hey, my religion requires me to jaywalk, don't write a ticket. That's not going to work. But if the state legal regime regarding the law in question has an exemption program built in, has a mechanism whereby anybody can request an exemption, and the state will, under certain circumstances, grant an exemption, then you can't deny the exemption to a religious objector without satisfying a very, very high standard. Think of it this way. Let's say you have a town ordinance in your town that has ordinances, a town ordinance in your town that says you cannot have more than 10 people in your house at any given time. But you can apply for variances for special occasions to that rule. And person A goes to the city and says, I want to have 12 people at my house for a prayer meeting. And the city says no. Person B says, I want to have 12 people in my house to watch the Avengers movies. And the city says yes. That's a problem. They have to say yes to the religious objector as well. And they have to, actually, I think they have to say yes to the religious objector, period, if there's any sort of, if there's any camel's nose under the tent for objections. So how does that relate to Philadelphia? Well, it turns out that the sort of the legal regime, which is actually just a contract, a form contract that Philadelphia was having all of their foster agencies sign, had within it a provision whereby the city, at its sole discretion, could grant a variance and exemption to any one of the legal requirements in the contract to somebody who asked for one. They could say yes or no. And it turns out they never granted an exemption to anyone ever, but they said they wouldn't grant one to Catholic Social Services. So what Chief Justice Roberts decided was, well, this takes you outside of Smith. This is that exception where you have an exemption regime, and CSS is asking for one, and you're saying no, and that's the heightened scrutiny. That's not a general law of applicability with no exceptions. It's a general law of applicability, a law of general applicability with exemptions, which takes us out of the Smith framework. So once again, in this particular situation where you have this weird contract, it's a plane flying overhead. I hope you can hear me. I live like 5 miles away from the municipal airport around here, and all these jackasses flying their little Cessnas over my house all the time. It's great for like depositions when I'm working from home. Anyway, it's gone now. So Chief Justice Roberts, in his majority opinion, says you have an exemption that triggers high scrutiny. You didn't meet it, and when you have this level of scrutiny, the state always loses. But he did go through, the sort of compelling interest test, and he said, well, the city identified 3 things that justified maintaining this exclusion against CSS. The first one was we want to make sure that we're serving foster children. And Chief Justice Roberts said, well, more people providing foster service is going to help foster children, so that's out. Two was we might get sued by LGBT families if we you know keep this up. And Robert said, well, you never have. That's speculative. And the third one was, well, we have an interest in promoting, advancing non-discrimination on the part of LGBT individuals. That was the big one. That was the question everybody wanted answered. And what's the answer? Well, Robert kind of sidestepped it. He said, well, if in theory a person for secular reasons could come and say that they don't want to certify same-sex families for foster families, so as long as you have the exemption in place, it's theoretically possible that you're not supporting that interest anyway. So it's all angels on the head of a pin for various reasons. First of all, no same-sex family had ever applied to Catholic Social Services for foster family certification and been turned away. This was all optics on the part of the city, and I'm not being as dismissive as I sound. I mean, it is important for the city to espouse a policy of non-discrimination. And sorry, my cat's trying to get out. Damn cat. That's an important interest, but in terms of like kitchen table politics for people who are actually in the foster system, apparently it didn't matter. Okay, so we still have no answer as to what happens when a law of general applicability runs up against a conservative religious belief that is views as looks askance at same-sex couples. The cat's getting out. Hang on. No, you don't get to come outside. Go away. You want to go inside? Can you just stay outside? Because you're going to want to come right back out. Stupid dog. You want to come say hi? Here's the puppy. I don't want to mess up. I don't want to move my camera because it'll fall over. But here's the nose. Okay, so, and if you read Chief Justice Roberts' opinion, it's his very workmanlike, extremely bland opinion. It's 15 pages long. It doesn't have his usual kind of rhetorical flair. Roberts isn't a big rhetorical flair guy, but he is a very good writer, and he writes interesting things, and he writes in a very engaging way. Not in this opinion. This opinion reads like an extern wrote it. If you're clerk, you know what I mean. So what did everybody else think? It was unanimous. The judgment was unanimous. What did everybody else think on the merits? Oh, and I should say, in light of all that, there was no reason to revisit Smith because Smith didn't apply. So that was Chief Justice Roberts' opinion. Justice Barrett, the raging theocrat who wants to turn America into literally Gilead, wrote a separate opinion joining the judgment, and her opinion was joined by Justice Kavanaugh and Justice Breyer, except as to the first paragraph. And the first paragraph said, "Yeah, Smith is kind of crappy. I mean, there's a lot of problems with it. We may be able to we may have to look at it again in the right case because this isn't the right case." Breyer didn't join that part of it. Kavanaugh did. And then she goes on to say, "Well, so let's say we get rid of Smith, and what's next? Like, does everybody who wants a religious exemption to a generally applicable law get it? That's not going to work. So how do we figure it out?" And she's just sort of, JAQs off and doesn't really put anything concrete on the table. And I'm thinking, well, that's your job. You're the Supreme Court. Like, figure it out, or tell the trial courts and circuit courts to figure it out and tell them when they got it wrong. Like, that's your whole job. People have this idea that people join the Supreme Court and they immediately want to start overturning cases and rewriting laws, and some do, like Gorsuch. Man. Barrett, not so much. Kavanaugh, apparently not so much. So that was, very wishy-washy, mealy-mouthed thing. Justice Alito, joined by Justice Thomas and Justice Gorsuch, wrote a 77-page opinion all about how Smith is terrible and should be overturned, which I'm pretty sure I would agree with as to the ultimate conclusion, but there is no way I'm reading that. Quite frankly, at this point, I'm sick of Alito's shit. He's a very cranky old man, and I'm not going to read all that. So the upshot is that we have 3 justices who are ready to overturn Smith. We have 3 who are ready to take a hard look at it, and 3 who are apparently just willing to go along to get along. So what happens now? Well, a couple things. So let's say that Philadelphia looks at the decision and says, okay, well, according to this decision, if we get rid of the exemption, if we say nobody ever gets an exemption to anything in this contract, we can go right back to excluding Catholic social services. And they might do that. They might take the mulligan and try again, get sued again, see what happens. That's what Colorado did against Jack Phillips. As soon as the decision came down, and there's a weed whacker now. As soon as the Supreme Court decision came down, the state of Colorado went after him again, filed a new civil rights lawsuit against him, intending to be nicer this time, I'm sure. And Phillips sued them back, saying that they were harassing him and violating his religious rights and singling him out and targeting him. What ended up happening was both of those cases settled. Jack Phillips and Attorney General Phil Weiser, great guy, just got together and said, okay, fine, we'll just leave you alone. We'll take the L on this one. Go bake your cakes. But something else happened with Jack Phillips. A private citizen, a trans woman who was a lawyer, went and asked Mr. Phillips to bake her a cake celebrating her transition, a cake that was blue on the outside and pink on the inside. And he refused. So she sued him privately. And just like yesterday or sometime this week, a judge found that, yeah, he violated civil rights law by refusing to bake her this cake. And the state wasn't the plaintiff in that. It was a private plaintiff. That's why it proceeded. So we'll see what happens with that. He's got more money than God behind him at this point, literally, because all the kind of conservative religious organizations are bankrolling him. We'll see if that goes to the Supreme Court. I'm sure they'll try. So that, I don't know, that gives me pause as to whether Philadelphia will just kind of take the L on this one or try it again. Airplane. But here's what I will say as kind of my parting thought on this, since this is way longer than I intended it to be. Thank you for watching, those of you who are still here. The fact that the Supreme Court is having trouble getting this question into its sights, this idea of, I want a religious exemption to a generally applicable law, but I can't get one, probably means it's not happening that often. And it is sort of a philosophical question that is important to a lot of people. Don't get me wrong. It's an important question, but the Supreme Court only decides cases that are... It only decides cases. The Supreme Court doesn't answer philosophical questions, it decides cases. And if it can't get a good case to decide on this, it probably means that there aren't that many of them. And that, authorities enforcing non-discrimination laws and conservative religious objectors are more or less living in peace and harmony for the time being. We'll see what happens. But I think it'll be a while before we get Smith in the crosshairs and something actually happens to it. Hopefully something good, hopefully something better than what we have now, which as I explained in the last video, I won't get into it now. I think Smith is bad, I think Smith is wrong, and I think Smith should be revisited. This would have been a good case to do it if Roberts hadn't kind of taken the easy way out. But there will always be another case, and maybe this time next year I'll be talking about the case that overturned Smith. Who knows? Have a great weekend, and thank you for watching.